Good afternoon and a very warm welcome to the final session of this series, Conversations with the Community, that was organized by the Singapore courts. Let me also extend my heartfelt thanks to Simon for his kind and generous opening remarks and to the National University of Singapore Faculty of Law for working with us to put this final session together. About a year ago, I spoke about the role of our courts in the first session of the series. In particular, I focused on two key aspects of our work. First, the court's adjudicative role to interpret and apply the law in a manner that respects the constitutional and institutional space of each branch of government. And second, the court's broader systemic role to develop and operate a justice system that is accessible to all and that meets the needs of our society. Since then, we've had 5 sessions in which we explored specific aspects of our work, and the topics covered included family justice, the restructuring and insolvency regime, and environmental law. We also discussed the critical importance of ensuring access to justice and how we can use technology to significantly advance this goal. I'm deeply grateful to my fellow judges who led each of those sessions. As we draw this series to a close, it is fitting that our discussion today turns to the rule of law as we conceive it in and for Singapore. Because ultimately, all of our work must be directed towards our core mission, which is to uphold and strengthen the rule of law. My address today is structured in 2 parts. I will first outline what I suggest the rule of law means in practical terms, and suggest how a shared and unwavering commitment to it has been pivotal to our nation-building efforts over the last 6 decades. And then, looking towards the future, I will explore the need at this time to reimagine our traditional conception of the rule of law on account of some significant challenges that are now upon us. Taking a step back, if we were to examine the historical origins of this concept, we would find that it was intended to apply to states and to matters falling within their legal systems. The principal objective of the rule of law was, and to a very significant extent still is, to regulate the relationship between the state and her citizens, and between citizens themselves, based on a framework of rational principles and objective reasoning. All of this is reflected in one of the most well-regarded and pithy descriptions of the rule of law offered by the late Lord Bingham in these terms. He said, "All persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws publicly made, taking effect generally in the future, and publicly administered in the courts." My central thesis is that while this notion of the rule of law has served us very well and remains at the heart of the mission of the law, we should move beyond it in some modest ways and adopt a renewed vision of the rule of law that is more inclusive, outward-looking, and holistic, and that places appropriate weight on 3 things in particular. First, the distinct and evolving needs of our court users and the barriers to justice that they may face. Second, the reasonable needs, expectations, and aspirations of the legal profession, and in particular those of our younger colleagues. And third, the decisions made by other judiciaries in key areas of law that concern global threats or challenges that affect the world as a whole, and where we have much to gain from collaboration and knowledge sharing. You will note that these 3 elements respectively target 3 key stakeholders in a justice system: the users, the legal profession, and the courts. And this extended focus is, I suggest, necessary because a proper conception of the rule of law today must also account for challenges that threaten the sustainability of the legal process, such as access to justice, and the sustainability of legal practice itself, as well as for the global threats that have emerged and that affect all of humanity. This in turn means that if we think of the rule of law as a set of values that are essential for the proper functioning of a legal and judicial system, then it must encompass values such as accessibility, proportionality, and coherence in order for us to better meet these challenges and to secure our vision of being a trusted judiciary that is ready for tomorrow. Let me begin by setting the context for our discussion. It has been suggested that the rule of law is an essentially contested concept and an unruly horse that is challenging to define. Despite this, I believe that it is possible to identify certain fundamental tenets of the rule of law that are generally uncontroversial, and we should strive to do so in order to raise public awareness of just what the rule of law means in practical terms. To be clear, my list is not an exhaustive one, but I focus on these core principles, at least as ideas because of their importance to any proper conception of and substantive discussion about the rule of law. The first fundamental tenet of the rule of law is accountability, which essentially refers to the idea that the power of the state is subject to legal limits and can be held to account before the courts. Almost 4 decades ago, this principle was articulated by the Court of Appeal in the seminal case of Cheng Xuanze in these terms. The notion of a subjective or unfettered discretion is contrary to the rule of law. All power has legal limits, and the rule of law demands that the courts should be able to examine the exercise of discretionary power. That time-honored principle has been cited and applied by our courts to this day. Another core tenet of the rule of law is equality. This encompasses 2 distinct but related principles: equality before the law and the equal protection of the law, both of which are enshrined in Article 12(1) of the Constitution. The first principle refers to the idea that everyone is equal before the law regardless of their status, while the second essentially requires that persons in like situations be treated generally alike. Where this is not the case, the court will examine the basis upon which these individuals are treated differently and whether that is justified by the object of the legislative or executive action in question. Next, the rule of law demands that laws should be clear, consistent, and predictable. And I've grouped these values together because they, along with other values, have traditionally been described as the formal aspects of the rule of law, unlike the more substantive aspects of the rule of law mentioned earlier. These values are crucial because we generally rely on the stability of the law to guide our actions both in the short and in the long term, and they apply with equal force to statutes and judicial decisions. In respect of judicial decisions, one key method that our courts use to advance these values is the doctrine of judicial precedent, which requires a court to apply the law in a manner consistent with prior decisions of a higher court, unless they can be distinguished in some way. And in respect of statutes, the Law Revision Commission and the Attorney General's Chambers completed in 2021 a universal revision of 510 Acts of Parliament spanning about 27,000 pages. This exercise, the first of its kind since 1985, aimed to use plain English and shorter sentences to make our laws clearer and more easily understood, especially by lay persons. As described by the Attorney General, this was a mammoth task, but it was a necessary endeavor to ensure that In his words, our legislation remains readily accessible by all. Another core tenet of the rule of law is transparency, also known as the principle of open justice. This reflects the foundational principle that justice should not only be done, but must also be seen to be done. And it goes directly towards the preservation of public trust and confidence in the judiciary and in its adjudicative processes. Our courts have held that a departure from this hallowed principle would be the exception rather than the norm, and it must be grounded in statute, as is the case in family disputes and arbitration matters, or in the court's inherent powers to do what is necessary in order to serve the ends of justice. Finally, the fundamental tenets of the rule of law that I've outlined rest on a crucial foundation: the existence of an independent and impartial judiciary. And this, I suggest, is another core tenet of the rule of law. In Singapore, we have implemented strong institutional safeguards to ensure judicial independence. The tenure and remuneration of Supreme Court judges are constitutionally protected. And to ensure the appointment of competent and impartial judges in the first place, the Constitution mandates that the Prime Minister consult the Chief Justice on the appointment of Supreme Court judges before he tenders his advice to the President, who then acts in his own discretion in making judicial appointments. The Chief Justice typically nominates candidates for higher judicial office for the executive's consideration, and for the junior judiciary, the appointment, deployment, and removal of these judges are subject to the exclusive control of the Judicial Service Commission, which is headed by the Chief Justice. Having outlined the broad contours of the rule of law as it has been understood, I turn to the pivotal role that it has played in the Singapore story. This point is central to the theme of my address because it is only by recognizing the importance of the rule of law to our nation-building efforts that we can truly appreciate why it is not just desirable, but necessary to ensure that it endures by, if necessary, by evolving in a way that makes it fit for future generations. This requires us first to take a step back in time to Singapore's independence. In 1965, Singapore separated from the Federation of Malaysia, and this resulted in the creation of this tiny and vulnerable, at that time, third world island state with no natural hinterland, no natural resources, and no common market. Under these trying circumstances, economic growth was seen as the only viable option to ensure Singapore's survival. To this end, the government made two strategic decisions which have been described by Mr. Ravi Menon, the former managing director of the Monetary Authority of Singapore, as being sharply at odds with the conventional economic wisdom of the time, but which proved to be Singapore's decisive advantage. The first was to promote a policy of export-led industrialization instead of import substitution. And the second was to promote foreign direct investment, or FDI, by attracting multinational corporations to Singapore. But this economic policy would not have succeeded without a strong emphasis on the rule of law as its foundation. This is because it is the rule of law that safeguards the rights of investors and the safety of their assets, which ensures that the threat of corruption can and will be effectively combated, and which facilitates the effective enforcement of agreements and the efficient resolution of disputes. Our founding fathers recognized all of this and were committed to the rule of law. In the words of Mr. Lee Kuan Yew, and I quote, "To attract foreign investment to Singapore, our strategy was to make Singapore a first world oasis in a then third world region. We had to distinguish ourselves from our neighbors by being more stable and secure, with a sound legal system and the rule of law impartially administered." Close quote. The rule of law has been central to Singapore's economic miracle, and the figures speak for themselves. Our gross domestic product per capita has grown from just $500 at independence to more than $80,000 today. And according to a UN report, FDI inflows reached a record high of $141.2 billion in 2022, making Singapore the third largest FDI recipient in the world, after only the United States and China. The rule of law has also played an essential stabilizing role in another crucial aspect of our nation. That is to ensure the peaceful coexistence of our multiracial and multi-religious society. This has been and continues to be an intractable challenge for many countries. Singapore at independence was not exempt from the challenges wrought by a racially diverse population, and this is evident from our communally charged exit from the Federation of Malaysia and the race riots shortly before independence, which have been described as the worst and most prolonged in Singapore's post-war history. Against this backdrop, our founding leaders recognized the potential of the rule of law to serve as the primary vehicle to achieve their vision of a peaceful and stable society where citizens could thrive regardless of race, language, or religion. And they took decisive and concrete steps to achieve this vision. Shortly after independence, one of the government's first major decisions was to appoint a constitutional commission, and its mandate was to consider how the rights of racial, linguistic, and religious minorities could be safeguarded through the Constitution. It may be noted that all 11 members of this commission were legally qualified, and it was led by Chief Justice Wee Chong Jin. One of the Commission's many recommendations led to the establishment of the Presidential Council for Minority Rights, which to this day scrutinizes all bills that are passed by Parliament to ensure that they do not discriminate against any racial or religious community. And successive governments have supplemented this institution with an entire suite of legislation designed to protect our racial and religious harmony, most notably the Maintenance of Religious Harmony Act, which contains measures to address hate speech, such as the making of restraining orders, as well as measures to safeguard against foreign influence in our religious groups. Without question, therefore, the rule of law has been a key enabler of peace and prosperity in Singapore. And its importance extends far beyond the two areas that I have touched on today, to areas such as foreign policy, urban development, and our safety and security. In all of these aspects, it can readily be appreciated that the rule of law has not only been an aspirational ideal for Singapore, but an existential necessity. But we should not assume that the rule of law will continue to serve us as well as it has if we were simply to maintain the status quo when the operating environment in which our societies and our courts function is changing at a rate and scale that is simply astounding. Just as the legislative and executive branches of our government have been more than proactive in introducing a slew of measures to ensure that our society is well placed to meet the new and evolving realities in which we find our lives, so too will the future of our justice system depend on our ability to anticipate and proactively address these challenges. And this will be greatly helped by imagining a renewed conception of the rule of law. To begin with, the first set of dramatic challenges that will affect our work are issues that threaten the sustainability of the legal process. There are several challenges in this regard, such as the increasing complexity of disputes, but I will focus on two in particular: access to justice and the sustainability of the legal profession. As I mentioned earlier, these challenges invite us to rethink our traditional conception of the rule of law to account for the distinct and evolving needs of our court users, as well as the reasonable needs, aspirations, and expectations of our younger colleagues in the legal profession. I highlight the latter point because this is critical to ensure the long-term sustainability and future of the legal profession. Let me begin with access to justice, which stands as one of the most pressing challenges affecting the sustainability of the legal process. While it has long been a challenge, the need to address it has become more urgent due to something of a new normal, where a significant component of our actual and potential court users are self-represented persons. There are various reasons for this, and they include the cost of legal representation, the manner in which we have designed some of our specialist courts and tribunals where the participation of lawyers is limited or restricted, and the broader trend of laypersons becoming more confident of representing themselves due to the democratization of knowledge and technology. In this new normal, we must ensure that all parties, and especially self-represented persons, have a realistic opportunity to commence or defend a claim and a fair shot at presenting their case regardless of their resources or legal literacy. Our justice system must not become the exclusive preserve of a select few, because the sustainability of the legal process rests on a shared societal commitment to the rule of law. And this in turn requires the public to trust that the courts will deliver justice for all, and especially for those most in need. The need to promote access to justice therefore lies at the heart of the court's broader systemic role. And as we go about this important work, we should reimagine our conception of the rule of law by placing greater emphasis on certain procedural aspects of the rule of law. These are values which have historically received less attention than the formal and substantive parts of the rule of law, and I suggest three in particular. First, contextuality. The appropriateness of the procedure that governs the dispute must be assessed against its context, by which I mean its size, nature, and complexity. Second, proportionality. This refers to the idea that even among cases within the same broad context, we should consider tailoring and structuring the complexity of the legal processes to the complexity of the dispute. We must not be fixated with the fallacy that the pursuit of justice always requires an exhaustive search for the truth. The effort that is applied to this end should be informed by the extent and importance of what is at stake. There is a plain and obvious difference between a small civil claim and a criminal case affecting one's liberty, for instance. And third, accessibility. This focuses on the need to ensure that the procedural architecture of our courts facilitates effective access by members of the public, and we can advance this by providing our users with practical assistance. These are values which I outlined and discussed in a lecture delivered to the arbitration community some years ago during the pandemic, and I will not repeat all the details of what I said then. But I do reiterate the point that while fairness is the foundational procedural norm that we should strive towards, these three values, contextuality, proportionality, and accessibility, are important second-order considerations that those of us who operate the justice system should embrace in pursuing procedural reform, just as much as those in the arbitration community to whom my remarks were directed. Of course, none of these values are new to us. Indeed, since the first session of the series last year, our courts have embarked on further initiatives which are directed towards these basic values. To begin with, we have implemented changes at the structural level by developing simpler procedural frameworks for certain types of cases. For example, the general simplified proceedings which have been available in the Magistrates' Court since 2014 were extended to the District Court last December, as long as the parties agree to this. Under this framework, the parties do not have to go through the process of production of documents, which is often costly and time-consuming. And the system is also designed to facilitate the settling of disputes through mediation. And just 2 months ago, our High Court launched the Express Track scheme to facilitate the expeditious resolution of certain civil matters that can be resolved within 4 days of trial. Some notable features of this new framework include the mandatory production of documents contained in the pleading and the disposal of interlocutory applications through a single application and without the necessity for oral arguments. Beyond these changes to our procedural regimes, we've also worked on numerous initiatives to further fulfill our assistive responsibility to our users. Central to this effort has been the work of our Access to Justice Program Office and the Office of Transformation and Innovation. In respect of the A to J Program Office, it has already completed 14 projects since it was established 2 years ago, such as the digital guided questionnaire that I spoke about last year, which provides users of the judiciary's website with relevant practical information based on their responses to a short series of questions. This questionnaire has been very well received, and we're considering replicating it in other areas. And in respect of the Office of Transformation and Innovation, or the OTI, it has been closely involved in various projects, such as the ongoing collaboration with Harvey, the AI startup behind the Eponymous tool, to assist users in the Small Claims Tribunal as they navigate the legal process. Let me turn to another issue that threatens the sustainability of the legal process, and that is the sustainability of legal practice. While we may be able to dispense with the involvement of lawyers in certain types of cases, especially those of small value, lawyers are critical to ensure society's continued access to the rule of law in so many other areas, both within and beyond our courtrooms. We should therefore broaden our conception of the rule of law to embrace the need to ensure that legal practice itself remains sustainable. This invites us first to question whether this is a real issue that we need to address urgently or at all, and I suggest that it is. Recent surveys and statistics suggest that the sustainability of legal practice for young lawyers is a growing concern. The International Bar Association in 2022 reported the results of its global survey of over 3,000 young lawyers, which found that within a span of 5 years, half of them were likely to leave their current legal job, and a fifth were likely to leave the legal profession entirely. In the United States, a survey of around 300 associates in large firms last year found that 1 in 4 plan to leave their firms within the year. And this seems equally to apply to us, as reflected in a survey that we recently conducted among applicants at this year's mass call. We received a total of 234 responses, which is slightly more than half of the total number of applicants, and the results are concerning. Around 2/3 of respondents indicated that they were likely to move out of legal practice in the next 5 years. And in the same period, slightly more than 1/3 indicated that they were likely to leave the legal profession altogether. These results are of concern not only because they represent the views of those who have just started on their careers in the law, but also because most of these responses appeared to be motivated by push rather than pull factors. In particular, a significant proportion of respondents indicated that their present inclination to leave was influenced by excessive workload or poor work-life balance or poor workplace culture. These findings ought to be of significant concern to all of us. And they should also be seen in the context of the global competition for talent and the fact that lawyers are increasingly valued by other industries. Apart from the issue of talent attraction, retention, and development, there is empirical research which suggests that there is a direct correlation between sustainable workplaces and financial performance. McKinsey analyzed 1,800 large companies across sectors and found a distinct trend that companies who perform better and who were more financially resilient over the long term were also those that prioritized organizational capital, which they described as the management practices, systems, and culture within each company. And then there is the further concern that unsustainable practices may also result in what has been described as ethical fading, where high-pressure work environments contribute to employees making judgments that are not in keeping with high professional standards. One prominent example is the Enron scandal almost 2 decades ago. The widespread fraud within the company was said to be attributed, at least in part, to a highly competitive and winner-take-all culture, which forced employees to take greater risks and to cover up their losses. We should therefore look at this issue urgently and strive to inculcate sustainable work practices in each of our workplaces. I suggest that the work ahead may comprise 3 broad components. First, we should consider whether there is an issue of mismatched expectations in the legal profession and a generation gap that needs to be addressed urgently. On the part of junior lawyers, it may need to be emphasized to them that a career in the law demands a considerable amount of hard work over the long haul, and especially in the formative years when there is undoubtedly a steep learning curve. And I have to say, I don't think that's going to change in the foreseeable future. But equally, we may need to convey to our senior lawyers that workplace practices have evolved over the years, and there has rightly been a shift towards more sustainable and mindful practices which the profession as a whole should embrace. To underscore both these elements, we may need to re-emphasize the importance of mutual trust between law firms and their employees, with due regard for the well-being of our junior colleagues while recognizing that this need not impede effective performance, and indeed, over the long term, will likely enhance employee satisfaction and productivity. Second, we should also develop concrete policies to ensure the implementation of sustainable workplace practices. The Ethics and Professional Standards Committee, which is led by my colleague Justice Valerie Thien and her co-chair, Mr. Jimmy Yim, Senior Counsel, is looking into this issue and will release its final recommendations in due course. And lastly, we should think about how to more effectively communicate and instill the values that are foundational to the practice of law. And it is these values that should be the main reason why we enter this profession and remain committed to it over the long haul. This includes values such as integrity, professionalism, and justice, which were highlighted by the Ethics and Professional Standards Committee in its interim report. In particular, we should impress upon our lawyers that the work that they do brings about real and concrete benefits to the lives of our fellow citizens, especially those who are most vulnerable. It is these values that are most likely to keep our younger colleagues engaged and committed to the long-term pursuit of excellence. Let me turn to the next set of challenges that should be accounted for in our renewed conception of the rule of law. And by this, I refer to global threats affecting all of humanity. In a world that is more interconnected than ever before, we will need a conception of the rule of law that is not only directed at ensuring law and order within our particular geographies, but which can also promote effective and coherent responses to rapidly emerging global threats through collaboration between judiciaries. To be clear, I consider this to be a third-order consideration that is subject to the first-order principles of substantive justice and procedural fairness, and the second-order principles that I discussed earlier, accessibility, contextuality, and proportionality. I say this because the ultimate aim of any justice system must be to deliver substantive justice in each case based on its own laws and in a manner that is fair and readily accessible to the public. I will elaborate on this need for collaboration later in my address, but let me first highlight two such threats and explain how they have already given rise to new and often complex legal issues that transcend jurisdictional boundaries. The first is that posed by the rapid advancements in technology, particularly in artificial intelligence. Let me acknowledge at the outset that AI can potentially be a real force for public good. I have spoken on previous occasions about the vital role that AI can play in the legal process, such as by promoting access to justice. But as cautioned by Professor Geoffrey Hinton, often described as the godfather of AI, there are significant risks posed by AI, and these include the possibility of more unemployment, the proliferation of misinformation, and even the potential of existential collapse, if and when AI reaches a stage where it operates beyond human control or understanding and is capable of making independent decisions. Against this backdrop, courts will increasingly be called upon to adjudicate on cases involving AI-related issues, particularly when harm is caused. It may be noted that many countries, including Singapore, have necessarily taken a cautious approach to regulating AI. And as a result, legislation may not provide an answer to some of these legal issues. In these circumstances, the courts may sometimes be called upon first to determine whether existing doctrines and principles in the common law can be relied on effectively, or whether there is a need to reconsider them or even to develop new ones. AI has already given rise to a host of legal issues across various areas of law. For example, in the field of intellectual property, courts across the world have considered issues such as whether AI-generated output can receive patent or copyright protection, and whether the training and use of AI systems infringes the intellectual property rights of others. AI-related issues are also emerging in tort law. For example, earlier this year, a tribunal in Canada held that an airline was liable to a passenger in the tort of negligent misrepresentation for inaccurate information provided by its chatbot. We are also likely to face issues arising from the imposition of liability for accidents involving autonomous vehicles, including questions of who should be held liable and the standards to which they should be held. And to be honest, we are barely scratching the surface with these issues. While what we have today is AI that is focused on the execution of a specific task or area, what has been referred to as narrow AI, some experts predict that by the end of the decade, we are likely to see AI that is capable of performing a wider range of tasks at a level comparable to or even exceeding human performance. In recent years, we've already begun to see AI make significant breakthroughs in areas involving deep human intuition and on some of the hardest problems across the sciences. For example, just 2 months ago at the International Mathematical Olympiad, widely regarded as the most prestigious mathematical competition in the world for students and that features some of the most complex math problems, AI accomplished what has been described as a massive breakthrough by performing at the top end of the silver medal standard, just 1 point shy of the gold medal threshold. And just last week, OpenAI released O1, the first of a new series of AI models that have developed reasoning abilities and which are said to be more accurate and more capable of solving complex tasks than previous models. These tools will not be equally accessible to all, and so they threaten to open the way to new types of inequality. And if AI continues on its path of exponential growth, this might mean that AI may one day come to be seen not just as an agent, but as an autonomous entity and actor that can enter into obligations and incur liability on its own. And this will give rise to yet more complex issues that we will have to grapple with and that we haven't even started to think about. This brings me to my second example of a global threat affecting all of humanity, and that is climate change. While this threat has long loomed over the horizon, it now seems to be closing in on us at an alarming rate. The United Nations Intergovernmental Panel on Climate Change has cautioned that there is a rapidly closing window of opportunity to secure a livable and sustainable future, and that the decisions and actions taken in this decade will most likely have both immediate and far-reaching consequences, potentially for hundreds, even thousands of years. The widely accepted scientific evidence, coupled with the need for urgent action, will inevitably lead to legal disputes that come before the courts, such as those that seek to hold public and private entities accountable for their active contributions to climate damage or their passive failure to mitigate it. We've already seen a sharp rise in climate litigation globally. Reports indicate that the number of cases around the world has more than doubled in the last 5 years. And just in the last few months alone, we have seen important decisions, such as the decision of the Supreme Court of New Zealand in Smith and Frontera, which was mentioned by Justice Philip Jeyaretnam at the previous session of this series of conversations. Smith and Frontera is a noteworthy decision because it involved a claim in tort based on public nuisance, negligence, and a novel climate system damage tort. In the context of a striking out application, the Supreme Court of New Zealand held that the plaintiff's claim should proceed to trial. The eventual outcome of this case may, I suggest, hold some significant implications across the common law world, particularly as it pertains to a branch of private law that is essentially judge-made. The interface between tort law and climate change is likely to give rise to new and complex legal issues, such as those relating to standing, proof of damages and causation, and that raises an even more fundamental question as to whether the conventional models of justice and dispute resolution are well suited to this field, or whether we should be looking at other models, such as the application of some variant of therapeutic justice that we have developed in the context of family proceedings. To better serve the needs of users in different contexts, we may need to explore differentiated or bespoke models of justice that would entail first identifying the specific stakeholders in a given area of law, then recognizing their likely goals and interests, and finally developing an appropriate procedural framework and overarching judicial approach with those considerations in mind. Of course, the climate and environment-related disputes that come before domestic courts will invariably reflect the specific areas that require judicial intervention, and this will differ across jurisdictions. In Singapore, it is unlikely that our courts will need in the foreseeable future to intervene in the public law space to the same extent that some other courts have done. And this is so because of the strong and proactive leadership of the executive branch in mitigating and in adapting to climate change. This can be seen, for instance, in the multi-ministry Singapore Green Plan 2030, which charts ambitious and concrete targets for Singapore to be a low-carbon leader in the region. Singapore, as a member of ASEAN, has also proactively engaged in cooperative efforts on environmental issues to promote sustainable development. That said, we could see claims and issues in private law, such as tort law, to address the harms caused by defendants who are based within Singapore and who, through their corporate vehicles, contribute to climate damage in the region. Climate change and technology are, of course, not the only global threats affecting all of humanity. As we have seen from recent incidents such as the COVID-19 and more recent Mpox outbreaks and the CrowdStrike IT outage 2 months ago. These other threats include global health pandemics, cybersecurity issues, and especially those arising from the profound impact of quantum computing, geopolitical shifts, and the ongoing phenomenon of truth decay. Together, these threats have coalesced to form a perfect long storm of challenges that are complex and lasting, and that will have a direct impact on our work, to borrow an expression first used by President Tharman. In these circumstances, I suggest there is a need to refresh our conception of the rule of law, one that transcends the focus on individual states and their citizens, and that embraces the value of coherence as one of the basic values of the rule of law. What coherence envisages is that legal systems, including judiciaries, should see themselves as part of a larger transnational system of justice and strive to take broadly coherent positions not only in areas of transnational commercial law, but also when responding to these new and emerging legal issues that have the potential to adversely impact humanity as a whole. To be clear, I'm not suggesting that courts should be at the forefront in addressing these issues. Indeed, consistent with the principle of judicial modesty that I discussed last year, the most effective response to certain issues may not come from the courts, and this tends to be especially true for issues involving polycentric social, economic, and political questions. But we should not underestimate the great potential of the common law to respond to emerging issues and challenges in an innovative and yet principled manner, particularly in areas of private law such as tort and contract. This is amply demonstrated by the iterative and incremental development of legal principles throughout the history of the common law, with one prominent example from our own jurisdiction being the ACB and Thompson Medical case. There, in the context of a mix-up during an in vitro fertilization procedure that resulted in the use of sperm from a third party instead of the intended father, our Court of Appeal developed a novel concept of the loss of genetic affinity and recognized this as a distinct head of damage. Let me also be clear that the value of coherence does not mean that all courts should adopt uniform responses. It cannot be so. Because, as I have said, I see coherence as a third-order consideration that does not override the paramount objective of any court, which is to deliver substantive justice in the cases that come before it. The reality is that our justice systems are shaped by and operate within cultural, political, and social conditions that are unique to our own country. This affects not just the laws that we apply, but at a more conceptual level, also our judicial philosophy. However, where possible, courts should strive to achieve meaningful convergence. And even in those instances where courts adopt differing stances on legal issues with a transnational character, they should do so with a broad understanding of how their decisions cohere within the larger transnational system. And after they are satisfied that there are principled reasons for adopting a different position from other jurisdictions. In this way, by promoting the value of coherence, courts can advance other key values that I mentioned earlier, such as clarity, consistency, and predictability. These values are especially important for facilitating international commerce by reducing uncertainty and costs and reducing the incentive for parties to engage in forum shopping. But more fundamentally, such convergence is likely to result in more effective responses to the common threats that affect us all, since, as the Secretary General of the UN has said, global challenges require global solutions. And all of this is likely to result in a stronger and more reliable global legal framework that is better equipped to handle the complex challenges of our interconnected world. How then can courts promote the value of coherence? In the past, this would have been primarily through our judgments, with the traditional view that they speak for themselves. But this needs to be revisited, and I suggest we can take this on two levels. First, in terms of our mindset, we should be more open to developments in the laws in other jurisdictions, including those with different legal traditions, such as civil law systems, because of the need to strive towards global solutions in the areas that I've just highlighted. Second, given the urgency of the challenges that we face, we need to make intentional efforts to engage with our counterparts in other jurisdictions. And we need to do so in a way that would better equip us to address these issues when we are forced to encounter them in our courtrooms by thinking ahead about them constructively and collaboratively with our counterparts, and where appropriate with input from policymakers. We should therefore promote what I've referred to as judicial diplomacy, by which I refer to communications and collaboration between courts in different jurisdictions in a manner that is structured and intentional. This is one of the key areas that I've sought to develop during my tenure as Chief Justice, to promote a better understanding of the critical issues we all face, to enable us to learn from one another, and to foster the possibility of developing broadly coherent responses. Apart from bilateral annual roundtables with key jurisdictions such as China and India, our judiciary has taken the lead in organizing various forums, and I highlight just 3 examples. First, the meeting of Chief Justices and judges in charge of technology. We recently convened the second meeting virtually to discuss the interface between technology and our justice systems. And one initiative that we're exploring with our counterparts is the development of a joint AI governance framework to regulate the use of AI in our courts. Second, the Judicial Roundtable on the Future of Justice. Together with my colleague on the Singapore International Commercial Court, Justice Anselmo Reyes, we convene a biennial roundtable where judges, academics, and policymakers can engage in a frank discussion on emerging issues affecting the justice system. We recently held the 4th roundtable in Durham University and will be publishing a book entitled The Future of Justice, AI, Big Data, the Environment, and the Courts next year, which captures the development of the ideas exchanged and the discussions that took place in Durham. And third, the Masterclass Program for Commercial Judges in Asia, which we co-organized with the Supreme Court of Indonesia just a week ago. The inaugural run successfully took place just last week, and it featured a deep dive of cutting-edge issues in commercial law with more than 60 judges from 16 jurisdictions coming together over 4 days of intensive learning. Allow me to conclude by returning to Lord Bingham's description of the rule of law which he advanced more than a decade ago. All persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws publicly made, taking effect generally in the future, and publicly administered in the courts. In the light of the points that I've discussed today, I respectfully suggest that we in Singapore might reframe this by supplementing it, adding at the end these words, through practices and processes designed to enhance access to justice and with the support of a sustainable legal profession. And reflecting its status as a third-order principle, I would add that courts should aim for coherence by thoughtfully considering developments in other jurisdictions that concern legal issues affecting transnational commerce or relating to global challenges that impact humanity as a whole. Let me be clear that this is not intended to take anything away from Lord Bingham's description, which he had cautioned was not intended to be comprehensive, and which undoubtedly captures and emphasizes vital components of the rule of law that are familiar to all of us and that continue to be relevant. But as I've sought to explain today, there is a need, at least for us in Singapore, to refresh that traditional conception from one that was centrally concerned with constraining the excesses of power to one that also takes due account of challenges that undermine the sustainability of the legal process and threats that affect all of humanity. We can move in this direction by embracing values such as accessibility, proportionality, contextuality, and coherence, and ensuring that legal practice is kept sustainable. And there is a more fundamental point to all of this, which is that our responses to these challenges will have a direct impact on the level of trust and confidence in our courts, on the court's legitimacy, and therefore the continued relevance of the rule of law to future generations of Singaporeans. Let me close by expressing my deepest gratitude to all the judges, moderators, and speakers who have so generously dedicated their time and expertise to each of the 7 sessions that we have had. I also record my heartfelt appreciation to the 3 law schools that hosted the sessions and to our Chief Communications Officer, Patrick Nathan, and his entire team for the tremendous amount of work that has gone into organizing these events. Finally, I thank you, the audience. This series of conversations was intended to provide a platform for the judiciary to engage the broader community on topical issues and to exchange thoughts and perspectives. And this would not have been possible without your keen participation and support. Thank you very much, and I look forward to the discussion that is to follow.